Section 154. Information in cognizable cases. Subsection 1. Every information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Provided that if the information is given by the woman against whom an offense under section 326A, 326B, 354, 354A, 354B, 354C, 354D, 376, 376A, 376B, 376C, 376D, 376E or 509 of the Indian Penal Code, 45 of 1860, is alleged to have been committed or attempted, then such information shall be recorded by a woman police officer or any woman officer, provided further that, Clause A, in the event that the person against whom an offense under section 354, 354A, 354B, 354C, 354D, 376, 376A, 376B, 376C, 376D, 376E or 509 of the Indian Penal Code, 45 of 1860, is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disabled, then such information shall be recorded by a police officer, at the residence of the person seeking to report such offense or at a convenient place of such person's choice, in the presence of an interpreter or a special educator, as the case may be. Clause B. The recording of such information shall be videographed. Clause C. The police officer shall get the statement of the person recorded by a judicial magistrate under Clause A of subsection 5A of section 164 as soon as possible. Subsection 2. A copy of the information as recorded under subsection 1 shall be given forthwith, free of cost, to the informant. Subsection 3. Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information, in writing and by post, to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him, in the manner provided by this code. And such officer shall have all the powers of an officer in charge of the police station in relation to that offense. So, what exactly is section 154 of the Criminal Procedure Code, 1973? In layman's term it is FIR, the first information report that we file when we want to inform the police of any crime that is cognizable in nature. So, if you, or someone you know is a victim of any sort of cognizable crime, the first thing you'll do to start a legal proceeding and a police investigation is file an FIR with the police. The information of the crime to the police can be verbal or written. In case it is verbal, the police will pen down your information and read it aloud to you. Whether an information is written or penned down by an officer or by someone on his behalf, has to be signed by the informant, after which they will record the information as prescribed by the state government. And then they will give you a copy of the recorded information, free of cost. But if the officer in charge of the station refuses to record the information given by the aggrieved person, he has to send the information, in writing and by post, to the concerned superintendent of the police. And if he thinks that the information does actually disclose the commission of a cognizable crime, shall start the investigation himself, or order any of his subordinates to start the investigation. It is further said that in case a woman is subject to or someone attempts to grievously hurt, assault her intending to outrage her modesty, rape her, or uses words or gesture intending to outrage her modesty, such information shall be recorded by a women officer. And the section further says that if the woman is temporarily or permanently, mentally or physically disabled, the information must be taken by a woman officer at her residence or at a convenient place, in the presence of an interpreter or a special educator. This information must be videographed, and then the police officer must get the statement recorded by a judicial magistrate. Thank you. That should be all for now. I'll come back again with another video.